girl, a wonderful girl, I'm the sweetest one in town. Can search for miles around, and no one like me can be found. I've got a smile, a wonderful smile, in a certain little way. Every time the boys get near me, they look at me and say, red hot mama, you're the one we need. Red hot mama, some charmer, yes indeed. They say that I should be in the follies, hot tamales, say that I got a pair of eyes just like old Svengalis. I confess that I possess the sweetest charms in town, and unless I miss my guess, the boys all follow me around. I could make a music master drop his fiddle, make a bald-headed man part his hair in the middle. I'm a red hot mama, but I'll have to turn my temper down. I'm the sweetest one in town. You can search for miles around, and no one like me can be found. I've got a smile, a beautiful smile, in a certain little way. Every time the boys get near me, they look at me and say, red hot mama, I'm the one you need. Red hot mama, some charmer, yes indeed. They say that I should be in the follies, hot tamales, they say that I got a pair of eyes just like old Svengali. I confess that I possess the sweetest charms in town, and unless I miss my guess, the boys will follow me around. I can make a Texas farmer forget his hay, make the devil throw his fork away. A red hot mama, but I'll have to turn my temper down. I'll have to turn my temper down. I'll have to turn my temper down. I'll have to turn my temper down.
Yo, good morning. How the hell are you, Hank?
I'm alive.
How are you?
Awake.
You're alive? Okay.
Second pot of coffee done. So
Yeah?
Yep. So I'll be awake at least until lunch.
Good. I am babysitting today, so Junior Jan is in the room with me, and he is currently playing Roblox. Whatever the hell that is. Good morning, Virgo Wraith. Good morning, Serial. Good morning, G. Good morning, everybody on Twitter and all the ones over on YouTube. Today we're here for the charging conference, which is essentially a pretrial hearing where they're going to go over jury instructions exactly like Hank described it yesterday. Because Hank is right. Do you remember describing it, Hank?
I took a educated guess.
Well, I Googled it last night, and Hank was 100% right. So they're going to go over instructions to the jury, last-minute stuff. It's probably going to take a couple of hours. We'll be here for it. They are not going to do closing arguments till sometime tomorrow, and then the case goes to the jury. Hey, unclean hands.
So since I was right and IR journalism, I must go journalist.
Yes, you have to go journal it. You have to do the journal thing. We have a big, not-so-secret Monday night coming up since Phil is out of town all next week. And the Suck It Phil, or Phil Sucks, whatever it is, slot is open. It is someone's birthday on, hey, Facebook Karen. It is someone's birthday on Monday. Do you know whose birthday it is?
And
It is Pants's birthday. And we have quite the extravaganza plotted out for Mr. Pants. Oh, boy. He probably should have never said it was birthday on Monday and he had nothing planned. Because now Mr. Pants has stuff planned for at least for an hour. And if he doesn't show up, well, we'll still be putting on the Pants show for an hour. on Monday night. So Monday night, 8 o'clock Eastern, 7 o'clock where it counts, 6 o'clock Mountain Time, and 5 o'clock on the West Coast, we will be having a very special pants holiday celebration.
We'll be putting on pants for his birthday.
Yes. So how much coffee have you had today, Hank?
I've had 2 pots.
2 pots. We do have celebrity guests lining up for some pants. So that will have to remain a surprise.
Good morning.
Good morning,
Hi.
Gio.
Hi.
So we were just making the announcement that Monday, instead of the Phil show, it's going to be the Pants birthday show.
Oh, wonderful.
Yes, and we've got some surprises for Pants if everything works out.
Nice.
So, Ariel, in fact, is going to bake a cake so someone can jump out of it. Now, Gia,
Yeah.
I know we risk you breaking a hip.
I can't. There's no more jumping.
Okay, we can have like some nitrous oxide in there and just launch you out of the cake.
It's got to be somebody who can jump. I can roll. I can roll out of the cake.
Well, that might be something Pants is into. I don't know. You know, Pants is strange sometimes. We'll work on that. Maybe between you and Touche, you can hijack someone to be thrown out of the cake, because I know both of you are strong enough to throw somebody out of the cake.
Or another rocket. Zoe, stop.
Yes.
Stop.
Yes. So
It's too early for that. Knock it off.
So get with Hank about the Rockets Red Glare for Pants Monday night.
Happy birthday, Pants.
Yes, happy birthday, Pants.
Wow, another June baby.
I know, that's strange. We
Mm.
don't normally see all these June people together on the same panel. It's like a plot or something.
And you're September?
September 30th, yes.
And what are you, Hank?
Hank doesn't celebrate a birthday.
Oh, okay.
He would just appeared fully formed as Hank, with full beard.
Born with a beard.
Out of the darkness one day, Hank
Yeah.
appeared.
Yeah, through the mist.
Yes. So we've got some wonderful music lined up. We already had Justin provided some music, and we will have some wonderful tributes. That's all I'm going to say. But today we're at our second to last step of the Karen Reed murder trial.
Yep.
We did get some feedback last night. I'm just going to address this. There are 500 million pro Karen Reed channels out there.
Really?
If you're looking, there's tons. But, I mean, it's easy. If we switched to being pro Karen Reed, our numbers would go through the roof. And we'd probably be making money off of it because...
Unbelievable.
Let's face it, people want to believe Karen Reed is whatever, and there's a grand conspiracy and all that crap. If you're looking for that, there are the 100 million channels out there for you to watch it. We don't have to be that channel.
Yep.
We don't necessarily completely back the police on this. They did screw up the case, a horrible snowstorm. But we aren't going to be labeled in with Turtle Boy and the rest of them who are completely beyond help. Just saying, my opinion.
Yep.
We see logic, we call balls and strikes, and that's what this channel's all about. If there is something stupid on the prosecution side, we call it out. If there's something completely insane on the green side, we call it out. But if you're looking for coverage of people who are 100% pro Karen Reed, rah, that ain't us.
Yep.
That's
This
everybody's
channel does not have to add our IQs together to make the double digits.
Yes. That said, all opinions are welcome, especially in our side chats, as long as you are not abusive towards the rest of the room. So coming in like we had a few last night saying yada yada yada, these losers, yada yada, get you banned. I don't care, it's disruptive. Keep the side chat going. So thank you everyone for tuning in to us, and that's just our stance.
Yep.
So that said, we're going to be with you for a couple hours today as they hash out essentially the jury instructions. This is what the judge is going to read for the jury to consider before going into deliberations. Tomorrow, they're going to do the closing arguments. I believe each side is given a chance to say what they're going to say. And then I think the prosecution gets a rebuttal at the end. I'm not sure. I don't remember how it works, and I've had a rough night.
I think they do. Maybe.
Yes.
I think they do. Because they have the burden of proof.
Yes.
Yep.
And then it will go to the jury. Every day that the jury is out, if it makes it through Friday, we will be doing a show to start the day for a little bit. When they adjourn, or when they adjourn that little hearing, we will come back as they always come back to end the day, and that's around 4 o'clock in the afternoon. I'll be monitoring it. We'll have a little live stream in the afternoon. If the jury comes back with the verdict, we'll be live when the verdict happens. I'll be monitoring the whole thing, and we'll have shows set up just in case. So you can get the coverage here. Not going to be broadcasting all day like we usually are, because I anticipate at least a few days for the jury to be out.
I wonder if they're amping up security around the courthouse during deliberations when a verdict is reached.
Well, I remember last year it was a carnival the last week. They had hundreds of people out there. Now, there are accusations those hundreds of people were of dubious means, but it is what it is. There were tons of supporters. There was supporters who mysteriously didn't come back this year into the exclusion zone.
Yep.
This year's been a much different animal.
Yep.
There hasn't been jury members kicked out. There hasn't been a constant presence of a blogger describing the lives of the jury.
Yep. He's got his own problems now.
Yes. Yes, that blogger is on trial. His trial finishes today for violating a protection order, basically related to this case, for his ex-girlfriend. His trial for witness intimidation, I believe, is later this summer. I don't think it'll be televised, or probably won't be covering it, but we will provide updates in the daily newspaper and newscast on this channel. You noticed we didn't have a newscast today, mainly because I was asleep, and I told Pants to go back to bed on his part. So, yeah. Plus, you really didn't want to read an article about Jeff Gray whining about Lane Myers. At least not.
No. And what's that one about Denver Metro Cardigan?
Denver Metro Audits has indeed sued Frauditor Hall. He has filed suit. Now, this is where it gets weird. Denver Metro Audits is based in Colorado. His lawyer is based out of New York City, while the case was filed in, I believe, San Francisco area in California.
Okay.
And it's about Frauditor Troll did a reaction video in 2022. In 2024, Mr. Cordova DMA filed for the copyright for his video of the material that Frauditor Troll used. So he is retroactively suing Frauditor Troll for the video he made 2 years previous to copywriting it.
And if Frauditor Troll is indeed Canadian,
for the record before the court is Commonwealth versus Cairn.
He'll never be served.
CR 117.
Yeah, he'll never.
Present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr.
Whoa,
Yannetti.
where's
And good
Jackson?
morning, Ms. Reed. All right, so Mr. Yannetti
Jackson
and
and
Mr.
Little
Alessi, you're
are not
standing
there.
in also, or Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's view of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical
in her own mind,
causation, and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorty Bello, that John O'Keefe suffered no injuries that were consistent with having a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesado, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific
I can see why Jackson's
Dr.
not
Welcher
here. He
actually
couldn't
did the
get through
proper
this
force
without
analysis and
laughing.
concluded Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler fermented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were three additional fact
All right, everybody,
witnesses
bye-bye.
who testified in defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight literally cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Aaron and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Yeah.
I meant Higgins, yes. Yeah, the same Brian Higgins.
You had to correct him. That's hilarious.
And gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe rolled. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and wish this court to enter required findings of not guilty on all three indictments.
Airtight.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The argument counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animals, then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay? All right, so regarding the charge, so we'll start with the
Take it easy,
defendant's
NCR.
missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think it's,
Oh, okay, so everything on this is done, right? The defendant's motion to present a witness argument and request for instruction, you're withdrawing that?
with regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your
Missing
proposed
witness.
instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right, you filed, I saw it in email, I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it, back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time, so that takes a lot of time out of today.
I would draw the court's attention. The Commonwealth does have a request for, and I understand what the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking an instruction on murder wrong.
All right, we will deal with that. I'm going to go through the defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a attention paid and some appellate decisions on the, each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear. Okay, so I'll give you that, Ms. Giannetti. There is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowdoin. I'm going to take a look, size this up with what I gave last year. I gave Bowdoin last year. I gave a Bowdoin instruction. I don't think the law objects, right?
We would object to the instructions.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowdoin, and I would incorporate, and I know there's no instruction for third-party culprit, but the Commonwealth would be making similar requests that counsel be prohibited from making a third-party culprit or Bowdoin argument.
Or Bowdoin? Or Bowdoin?
I'm sorry?
You don't, Commonwealth, the defense should be allowed to make a Bowdoin to argue Bowdoin?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowdoin or third-party culprit in this has come from questions from defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction in the argument based or predicated in the case law on evidence, not, and obviously as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a Bowdoin or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the vote. And Bowdoin is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowdoin, but I'll take a look at it. Ms. Giannetti, what is the Bowdoin evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials, active evidence, chain of custody was contaminated and corrupted. There was evidence of the bias, the lead investigator, failure to pursue other suspects, specifically telling friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was one person and one person only. And just responding briefly to Mr. Lally comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were
I think what Melly was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowdoin, and I am going to instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit goes to Bowdoin. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate, but I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of
Wow.
that. Not third-party
Big
culprit,
ruling.
pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowdoin defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, this clarification.
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on case, I just wanted to, Colin does have an objection to the DGQH instruction that's at the top of the data.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG argument that we would have at a police station, but, these days, Your Honor, it's common knowledge. Everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to be.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes back to the issue of custody and my client being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from being, and it did not end in any sort of custodial situation.
Verified that they can't use a third-party culprit.
As far as there's already been within the same requested jury instructions or requested remaining practice, and then following the DGM language in the defendant's requested jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of remaining practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having his testimony from the stand, that initially she said she was fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not in the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that arises to the level of the DQP instruction. So So I would ask basically that everything on page 8 prior to the voting instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And, Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is
Good
withdrawn.
morning,
So is the.
Cynthia.
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We'd ask the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language comes.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified.
Kaylee is John O'Keefe's minor
All right, so
adopted daughter.
Did I give it any other time that
We did not see
there's
that
another
testimony.
event that I should highlight? I don't think so.
I don't think there was an instruction of that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the part of that act being linked to the beginning's text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
So,
It'd be nice.
1 second, let me just pull that up. Okay.
Your Honor, Commonwealth's request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these facts and circumstances.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous in this equation, and don't explicate the jury. To avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, non-intent to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the model.
If I alter it, it means I remove those two. That's all.
But no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's rulings.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now.
So he's handing it to them now.
Sure, thank you.
Huh.
All right, so
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it, and I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have to redact it, so we
Okay.
redact it. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got different copies to the Commonwealth. Can I hand a
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least looks like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must get it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth will submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Lowell, in which he had similar issues and had, I believe, used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court a copy of it, a copy of the docket, but that may somewhat helpful with the court's thinking about it.
Okay, was that our murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lowell is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially? and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy, please?
Sure.
This is the
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional field instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to these arguments of the jury related to specific areas which we would need judicial approval. So the two areas that are sort of listed within that we would like to make some arguments with the jury regarding is the defendant's taking of the Lexus from one metal tab and to her parents' residence indictment, and then certain statements made in reference from the various clips of the later statements.
Okay.
In particular, would be the one where essentially she says that they came to her.
Okay.
The exact location.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, quickly, object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redaction.
that's great. Thank you. One less thing you all have to do today, okay?
This is Mr. Alessi.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need a Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy. This one.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah.
It should become ID.
Yeah, so we'll switch it back to ID, and this will just be 209? All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it redacted the NNN or is it, no, it can. It can stay there.
Okay.
But is this the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So there has to
Our
be-
thinking is it needs to be sent back to letters for
Yeah.
ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209, yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language for further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Lessie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt that the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie. And that led to a series of questions and a series of answers. And I want to go right to the end because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, you know, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them, but I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue, and I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was, Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Very briefly,
Keep your voice up, please.
yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the trial, extended exchange with a witness on the stand, things can happen.
You're echoing.
Acknowledged
But
and
You're echoing.
accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the
I don't hear an
truth
echo.
as far as the evidence is concerned that were
He's
rejected
muted
by
now,
the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi, okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise for the court, please.
Nice.
Is there already one of these, like, are we swapping?
Yes.
I expected more drama.
Yeah, there was just a little drama at the end there with the instructions about what happened with the holes in the back of the shirt.
It was a mistake.
I thought it was already addressed and taken care of, but
it was, but they're trying for any advantage in those instructions.
Look how stupid the prosecutor is. Doesn't even know what damage was done to the shirt.
Yeah, just like the start where Yannetti was pressing to have the entire thing dismissed based on 100% glowing endorsement of everything the defense did. Everything was perfect, including Lucky's insane ramblings. All of this proves she was not guilty. So they were pie in the sky stuff today. They were trying to get everything in at the last minute, because this is literally their last chance to get something in.
Even the Commonwealth agreed with our stuff.
Yeah, so let's see. So for tomorrow, we normally start at 8:55 a.m. Tomorrow we'll probably get here around 8:30 a.m. just in case they do start early. I'm sure we'll find something to fill time with if we need to, but it's only a few minutes, and a few times Griffey has bribed us to go early anyway. So not that bad. We'll just sit here and talk if need be. Tomorrow, after they go to the jury, okay, it depends on what time the jury gets the case. If it's within an hour of close, we may just sit here and do some drunk girl until they close shop, provided that the jury doesn't immediately come back with a verdict. If it's early, like 2-3 hours, what we'll do is we'll end the show. Then we will come back around 4:30 and then have a show from 4:30 until 5:15-ish Eastern time. So that way we're set, and that gets us covered. We'll do the same sort of thing the rest of next week as long as the jury is out. That said, anybody else got anything?
Goddamn bondsman.
Yeah. Are you finally out, Phil?
Took
Remember,
forever.
folks.
Took forever. You know, they tried to shortchange me on the value of the Pope Mobile.
Pope Phil was in custody last night due to, what was it? It was the overflowing stench of death from the property from all of those unused sidebars you've allegedly been letting pile up?
No, it was a violation of my First Amendment freedom of religion. I'm suing. 1983. 1983, I tell you.
Now, what about these rumors that you are trying to flee to Canada next week?
What form of time machine are you? What form of time machine are you using to get back to 1983?
My neighbor's DeLorean.
Oh boy. So yes, the FDA is at the property now, cleaning up what is estimated at 5,000 unused sidebars that are apparently rotting on the property, is the allegation.
The good news is, because of the current administration, the buffoons of the FDA don't know what the fuck they're doing. That's the good news. That's the good news.
And I'm sure a sizable donation from the Church of Phil will take care of the rest.
Yes. Yes, it will. Yes, it will. Some 20-something-year-old named Big Balls is here. I don't know.
Okay. In other news, Chile de Castro did not go live last night. We will have coverage of Frauditor Troll being sued by Denver Metro Audits. In the most bizarre lawsuit, okay, essentially what happened was Frauditor Troll did a reaction video of a DMA video back in 2022. In 2024, DMA actually filed for copyright on that video and has legally has copyright over his video, not the Frauditor Troll version, but his original video. So now he is suing retroactively Frauditor Troll for copyright infringement because now he owns the copyright, but back then he did not, and he says that supersedes anything.
Oh, I'm sure it will go very far. Yeah.
He, of course, is having trouble finding Frauditor Troll, as the address listed for Frauditor Troll is a holding company in New York, which provides provides storefronts and workspaces for various organizations. And there is no suite number provided, plus the fact that he thinks that Frauditor Troll is a Canadian. So he may be asking this to go on without fraud or troll actually being served, which is gonna be, yeah.
That won't
Yes. Yes. But this is a federal civil rights lawsuit. We will have details in the paper tomorrow morning. Yeah, he went this went under the radar.
Frauded or troll? We watched a video on Biggin yesterday.
Yeah.
Yeah.
And a frauded or troll video, and it's a staged incident between a woman and a police officer. There's been tons of staged ones on airplanes. You know what I mean? He actually showed this as being a real situation. Everybody in side chat's going, "This is fake. This is staged."
Right.
Is that how desperate he is now?
I do not know, and we are not making that official accusation. Should someone get litigious on his own, we are not. So
we're not talking about DMA. We are talking about Denver Metro Cardigan, which is a completely separate, made-up person.
No, she's saying that fraud or troll was playing these videos.
Yeah.
And
yeah,
also, I do have to give props to. Let me finish this one. We do have to give props to Troll Media Group for originally breaking the story and alerting everyone to this actual lawsuit. They found it first. Hats off to them. Go ahead, Hank.
Good job.
Do you have any proof that troll, frauded or troll is not a made-up entity?
Who knows?
I think he is a completely made-up entity.
Right, he's entertaining. That's I don't know how seriously you need to take him. He is entertaining.
Yeah, I haven't watched him in a long time.
Yeah, he's usually up against us when he goes live. So I think the last time I watched him was the sentencing hearing for DMA, of all people. So, anywho,
by the way,
yes,
you did get a shout out by a big dummy.
Okay.
We did, yes. Dummy Kruger had a post on the Lay Myers docs. So
yes, and then Patrick J. Darcy then gave Dummy a shout out, but our name was on the screen the entire time from the shout out from Dummy Kruger.
Yeah.
So, yeah, Patrick, please, you can always give us a shout out too directly instead of just Really Cool News being on the screen for the entire broadcast. That was hilarious.
At least we're on screen. At least we're on screen. Take the wins where we can.
Finally, Monday night is Pants's birthday. We will have Pants's birthday party on air because the Second Film Monday is suspended as Phil will be in Canada visiting Kentucky, wink, wink, eating poutine, wink, wink. Biscuits and gravy, that's what he'll be doing.
I'll be in the land of we'll be in Appalachia.
So, folks,
are you
please
taking the
come.
bourbon tour?
I am taking the whitewater rafting, yes.
So please plan on being with us Monday night, 8 o'clock. It's going to be a special show. I've got some special things lined up. Wink, wink. That might make it worth.
Nudge. Know what I mean?
Yes. Including Gia launching. Gia has to get with Hank about launching someone. What was it, Gia?
I don't know. Remember. I'm not jumping out of anything.
You said you weren't going to jump out of a cake, but you could get Hank to set up an explosion or something to launch someone out of the cake who's not you.
Coke Dog's ashes.
There's no ashes left.
I thought NCR said they landed on his yard.
He's completely mistaken. NASA was tracking the debris field heading straight for Jim's Uranus. And they suspect it's going to cause a noxious smell emitting from Uranus for the end of time.
Okay, then. So, Monday night, we've got some big things planned. And yes, Popeville may be sending in a special statement from Canada.
That's all, yeah.
Kentucky, whatever.
Yeah, Kentucky. Yeah.
Through his attorney.
No, he might be doing a direct statement via video.
Oh, okay.
From Kentucky. So, Canada, whatever.
Will the phrase of "boy, you got a pretty mouth" be in that video?
Maybe.
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 Boy, you got a pretty mouth. Because he's in Canada. Or Kentucky. Anywho, we will be back with you tonight at 8 o'clock Eastern for our normal Jim Sucks Thursday night. We will be discussing ins and out of Karen Reed and other situations, the usual stuff, plus some drunk girl. I hope you all can meet us or be with us there. And remember, please have a safe and happy afternoon. With that, we're out of here. Have a good one.
Bye. Bye. Your day. Please come back for tonight's show. Gia planned something very special.